It was heard at length, Lordship. The matter has come today, but there is a special bench going on where day-to-day hearing has been continuing, and my turn is now. I have already completed, but again, I have to complete it today. So I'm praying for adjournment of this matter till next week, Lord.
Lord, if your Lordship should recollect, the matter was heard at length. Matter was almost closed. Then we filed an additional affidavit on 26 to 24, wherein we brought in notification whereby some villages were included or excluded, whatever it is. Now, on 4/3/24, Learned Advocate General prayed for time to file an affidavit. So that is how the matter is continuing. It is our submission, my lord. We are not pressing this affidavit. So matter can be closed for judgment. We are not pressing this affidavit.
I may object to that also because a lot of arguments have taken place on that affidavit also. Let the matter be taken up on Monday, Lordship.
No, my lord, when Lordship says heard the matter at length, there cannot be repetition of the arguments. Only because of this, the matter is dragging now. Now we are withdrawing this affidavit. We are not even pressing this affidavit. Everything good now.
The legal point here would be, Lordship, whether a affidavit can be withdrawn or whether it cannot be pressed. That is an issue. I would like to address on that.
That is a different thing. That is a different thing. Only thing is that
Adjournment for today, Lordship. That is my prayer.
then what we'll do on one condition, we'll fix it, but on that day there will be no adjournment.
In fact, in all the cases, they are also on the other side, Lordship.
No, whatever it is, let there be no adjournment.
No, my lord,
And then-
no, I'm not objecting. Had it been a case where my learned friend is yet to conclude his argument, that is a different issue. Now, an affidavit was filed and reply was sought to be filed against that. That is how the matter was taken on 2-3 occasions. Today, matter has come for that affidavit. Apparently, they have not filed the affidavit. Now, we are saying we are not pressing this affidavit. That's all. We are not pressing this affidavit. All that we have brought on record was some villages were included. And law will take its own course. If your lordship decides in our favor, in any case, this will go. Only by an illustration, we brought this on record. So there is nothing to adjudicate on this.
We'd like to file written arguments also. So on Monday, we'll file the written arguments. On
That is okay. Written argument for, we will also file our written argument.
Okay,
on that.
I'm not saying anything.
Huh.
We were just saying on his request, we'll adjourn it, but Monday may be difficult. One is not on a hearing day.
Tuesday,
Tuesday.
Thursday, whatever day.
Tuesday.
Heard Mr. K. N. Chowdhury, Learned Senior Counsel, assisted by
Tuesday.
Mr. M. Gopal, Learned Counsel for the petition. On request made by Mr. D. Saike, Learned Advocate General Assam. This is the matter on
Tuesday.
23rd.
23rd. My lord, we will also file our written argument on Monday. Only for that limited purpose. Deep level. And my lord, there will be no further adjournment.
Yes.
Yes.
We concluded our arguments, Lordship. It is as if we are taking adjournment. We have completed, we left the court. Then they filed a affidavit, fresh affidavit. Now they want to withdraw it because that is acting against them. Deeply obliged, Lordship.
What is it?
It's a transfer matter, my lords. He has already joined, my lord. Only notice may be issued tomorrow, my lords. And identical matters are fixed already, my lords. It's item number 5 to 22. Identical matters. Tomorrow, my lord.
5 to 22, today's list.
No, my lords. Tomorrow. Tomorrow's list, my lords. So this matter may also come up tomorrow, my lords, along with those matters.
Let it come up on Monday, we'll see.
But But tomorrow, my lords, on those matters also, notice is yet to be issued, my lords. So in this matter also, my lord, there is no question of interim, my lords.
Okay.
My lord. Deeply obliged.
Lordship, I'd like to mention item number 30 to 34. It may be adjourned for today with the consent of the other side and fixed for next week.
32,
34.
you have 40?
I am appearing on behalf of Mr. Esbora for SSA.
How about the petitioner's counsel? Have you informed them?
Yes.
Who appears for the petitioner? Oh, Gautam.
I
Is it-
item number 30.
Is it okay? Okay, on request made by MS
J. Rajkumari.
J. Rajkumari, learned counsel appearing on behalf of Mr. S. Bora. Learned standing counsel,
SSA.
SSA, list the matter when?
Next week.
After 1 week.
You can take it up on 38 or
Okay, on 30.
May I please your lordship? If I beg to mention for upgradation of item number 39, lordship. Yesterday, your lordship was granted us liberty to make a mention. Lordship may taking up the matter immediately after motion matter, lordship. That IIT matter, lordship.
May I please your lordship? I'm praying for listing on next Wednesday, my lord. The matter is supposed to be listed after 4 weeks. Last list is on 15/5. So matter may come next Wednesday,
Not next week. Let it come up on Friday.
Friday, my lord.
Yeah.
August
26.
26.
May I please your lordship, with the consent of other side, I would like to mention item number 12. It may be listed after a week.
Okay. You have 4?
B. Prokasta, JP Borwa.
On request made on behalf of B. Protestal and the council for petitioner, list after 1 week.
May I please, your lordship?
Mm.
Lordship, I beg to mention for listing a contempt matter. Lordship, matter relating to non-payment of salary.
29, 29,
Lordship, it must be earlier.
29, 29.
Okay, lordship.
May I please your lordship? I beg to mention 3 contempt cases. One of them relates to non-payment of arrear salary, the other 2 non-payment of superannuation pension.
31st.
Obliged. May I please your lordship? Lordship, I beg to mention item number 25 for adjournment. MSG Borgohai out of station.
Who? Go ahead.
So,
Okay, on request made on behalf of MSD Borgohen and the council for the petitioner. List after?
first week of August.
Okay, list after 2 weeks.
Obliged.
May I please, your lordship? Lordship, I beg for listing a read petition, lordship, for tomorrow, lordship. Lordship, urgency is that, lordship, the petitioner will retire on 1st of August, lordship.
We'll have it on Monday, not tomorrow.
Obliged.
Just me to talk to one.
In the second case, lordship, notice has already been issued and they were directed to file affidavit, but no affidavit is filed. And in the first case, lordship, notice is yet to be issued.
Second affidavit will be sent.
Yeah, yeah.
Instruction.
That's it.
First, second.
Yeah, same issue.
Okay, heard, then come learn from. Issue notice. Can you hear me? MS. He does, Sunday council. Secretary.
Second.
Secretary. Appears for respondents, 1. 1, 2, 4 and 5.
1, 2, 4 and 5.
1, 2, 4 and 5. Finance.
3 is for finance.
Yes,
A Sunny.
A Chalia, then the Sunday council finance department appears for the responsibility. notice on the side. Over extra copy. Respondents are local file counter. List of the 4 weeks. And in the other writ petition, third M Khan and the council for the on request made by MS B Das, then it's standing council, secondary judicial department. 4 weeks time is allowed to file counter. Please start.
If you, extra. You.
Extra copies you
Extra
furnish.
My lord.
If you next.
It is my lord. My lord, in matter, we have filed our affidavit, detailed affidavit yesterday. Same is not tagged on it.
Where's the petitioner's counsel?
Next, your lordship.
Have you received the counter affidavit?
Just, yes, sir, done that.
Yesterday,
I was going to take this matter after a week in case. It's a detailed affidavit. It contains everything.
lordship, the petitioners are the OBC category candidates, lordship, they applied for the.
Are you
JNT
filing a reply to the counter or not?
In the meantime, lordship, the seat for the petitioner may be kept.
No, let the counter come, we'll see.
And the petitioner of the selected candidate lordship and subsequently the, as per their affidavit lordship, they prepare the second waiting list lordship,
Okay.
excluding the petitioner lordship,
Your good name?
Amjad Shah.
But sister M. Z. Shah and the counsel for the petition.
R. Chauhan on behalf of R. S. Chaudhary.
Mr. R. Johan, Learned Counsel, appearing on behalf of MS R. S. Chaudhary, Learned Standing Counsel and BS. Submits that they filed a counter affidavit on
Yesterday, Lord.
yesterday, 17th. Registry to verify and place the same on this one. Some emergency is there, isn't it?
Urgency is there, lord. The petition
24th July.
And four is, item 4 is also similar. That it also come on 24th.
Same.
Yes.
lordship 25th, I 24, I am not available. Oh, yes.
Great. Also,
5.
May it be your lordship. Lordship, today the matter is fixed, lordship, with the understanding to pass necessary order. Because they have received instruction and also direction is given to file affidavit. But affidavit is not filed, lordship.
Your lordship, we have received the instruction, your lordship.
That is what you said the
Yes.
other day.
Yes, your lordship, kindly 2 weeks' time may be granted to file our affidavit.
Not a
your
matter because my respectful submission is the ground for which the order is passed. It does not warrant to pass such order, lordship. Because the director, the arbitrary manner, the order has been issued.
Your lordship,
Lordship may kindly take up the IA lordship. What was the complaint? What was the complaint that lordship will find at page 17 annexer 1 type copy lordship? Because this was the allegation of complaint.
Oh, this.
So ultimately they receive. Our lordship, for argument's sake, there is a delay of lordship 7 days or 10 days. Because they are complaining they have not received the salary for the month of April 2024 in due time. That is the first week of the May. Suppose there is some delay. But that delay lordship does not warrant such a order lordship. That is why lordship I am pressing hard lordship for protection lordship.
your lordship, kindly 2 weeks' time may be
Yes.
granted, or your lordship.
Lordship may grant-
The instruction which has been provided, your lordship, I may allow to
And-
produce it.
And my, yes, Lord, then, and my lordship, the other submission is that this order has been issued at the behest of the respondent number 6 to 9. Because they are the president, and they have make a conspiracy lordship, because when I raise allegation, because ultimately what happened,
See, Deka, what is happening is that maybe the allegation that you are saying that the allegations are not correct and that you have taken your steps on time.
lordship,
All right. But you have already been put under suspension
true lordship.
by 18/5/2024. So now to reverse that, maybe let them file an affidavit and then you can rebut that by way of filing a reply. Then we can dispose of this matter at an early date.
I
Because,
mean, not 1 week time, your lordship, I will
One
be
week
filing
time is
1 week time,
that
your
is fair
lordship.
enough.
yeah, that to otherwise my appearance that in the they will initiate the DP lordship. So that may
No,
not
no, no,
be.
that when they initiate the DP, you can come forward. That
So that observation will be done lordship.
no,
But-
I'm not making any obligation. That
Because,
may aggravate more.
because otherwise, lordship, we have to lordship, consider what is the actual ground or the facts lordship for suspension. Their lordship instruction is also is that because of the complaint, I was placed under suspension. But what was the complaint? They received not salary for the month of April in due time.
2%
Ultimate-
salary has been stopped, your lordship.
No, they stop. Lordship,
After
stop
getting
means for
Stoker's notice,
only
They
there is
signed it.
there is delay of only 10 days. So for delay of 10 days, even for argument, I admit, yes, there is some negligence or lordship delay. Delay for how many period? Only for 10 days. They receive salary on 18th of May. There is no denial lordship.
But they call another council. I must be the standing council secretary division. Suppose that she has received instruction and praise for which time. Like the praise of. It's now. 26 next week. We'll have.
Till then, also further proceeding may not be initiated lordship. Kindly lordship, further proceeding lordship. Let us see on 20, further proceeding may not be initiated.
Okay, till the next certifiable date, no coercive steps shall be taken against.
Lordship. Deeply obliged, lordship.
6.
Lordship, this matter is fixed today for the respondent to file their stand in the matter, Lordship. As per,
We have received the instructions. We'll be filing our affidavit accordingly. Lordship may kindly give us 3 weeks. We'll be filing our affidavit.
You want notice to go?
Lordship, notice may go, Lordship.
We'll issue notice.
Lordship.
But Mr.
As Chakravarti.
S. Chakravarti, Learned Counsel for the issue notice. Who appears for the health?
Lordship, health, I'm
Mr.
M. Here, Lordship.
M.
Here, Lordship.
We
I'm
have
on behalf of,
Learned Standing Counsel.
no, Lordship, I'm on behalf of Mr. B. Gugoi, who is the standing.
M. Puyan, Learned Counsel appearing on behalf of Mr. B. Gugoi, Learned Standing Counsel Health Department appears for respondents.
Respondents. 1, 2, and 4.
1, 2, and 4. So. Petitioner to take steps for service of notice on the respondent.
Lordship, respondent number 3 also appeared, Lordship, through a steering council. Last okay.
Who was appearing?
DP,
Lordship, it's Pharmacy
DP
Council.
Bora, I think.
No, it's Pharmacy Council of India. This will be a union thing, Lord. CGC, I believe.
Anybody? CGC?
Pharmacy council.
Pharmacy Council.
Pharmacy council.
Lordship,
I can accept.
Mr. R.K. Dev Chowdhury. Then the Deputy Solicitor General of India. Appears for the respondent. Notice on respondents are complete, however extra.
Lordship, only Lordship, the interim order passed on 21/6 may be continued, Lordship.
No, no. How much time you require?
Lordship, 3 weeks time.
Respondents are allowed to file contract. Please after 3 weeks. What interim is there?
Lordship, para 11, Lordship. I'm an university, Lordship. Regarding the entrance examination, the university is kept aside, Lordship.
interim order passed earlier to continue.
Lordship.
Much obliged, Lordship.
38 of supplementary list motion.
May I please, your lordship? Lordship, kindly carry the last order of this.
Lordship, may I please, your lordship?
One,
Lordship, I pray for 2 weeks' time, your lordship. Lordship, the proposal that was sent on 12/10/2023, your lordship, we have found some, that there were certain documents were not sent with the earlier proposal, your lordship. So now we have asked for a fresh proposal with the required documents. So lordship will give us 2 weeks' time, lordship will process it, your lordship.
okay. But Mr. M. Khan, Leonard Counsel for the petition. MS D. Mushari, Leonard Standing Counsel,
Secondary education. Department.
Secretary Education, praying for 2 weeks' time, whenever that is. Praise the Lord. This time.
Any date may be given, lordship. My lord, rather difficult. Any date in the first week of December, lordship.
Huh?
In the first week or second week of December, lord. Sorry, August, lordship.
Please, okay, 5th August.
Lordship, obliged, your lord.
39 admission.
My lord, please. My lord, last, I had taken through the statements of various. When they come in. Records. My lord, 1 minute. Show the paper. Records. So, my lord, let me put some bullet points so that by this time, my lord will appreciate what has happened. My lord will see the records again, my lord. So from the statements which have been yesterday I have read out.
Yes.
So firstly, it has come to the light that petitioner number 3, Perisu Srinivas, reserved seats for 4 persons in a pub in Rudraksh Mall for the night celebration on 31st night. The booking was made on 22nd of December. That fact has come out. My lord has seen from his statement, he has said that booking was made earlier. Now, here, let me just tell one small fact here. I'll elaborate this little later. While they were submitting and interacting on 5/1/2024, the first DCC minute, he did not supply the documents which were there and other records. Other details were also not shared. I will show that. Point 2, which I have shown, my lord, that petitioners did not make any entry in the register at the gates before leaving the campus. That is an admitted position. Pen. Affidavit, sir. Affidavit. And statement of EA. My lord. So this is an admitted position, my lord, that that they did not make any entry at the register while leaving the campus, even though it came to their mind, but they did not do it. Third thing which they have admitted, that they did not make any entry in the hostel regarding their trip to the city and did not sought permission from the competent authority for staying outside the campus of IIT Guwahati. It was admitted by petitioner number 3, my lord, that in his written statement, that their plan was to stay till New Year celebration. I will show that, my lord. Just one line, and my lord will my lord will take the Srinivas statement again for a moment.
Srinivas.
Yes, my lord. Srinivas statement.
Yes, second page, my lord. Srinivas statement, second page. At the last 4 lines, my lord. My lord has seen. It is starting with the word around 10 p.m. See, my lord will see the last line then. Our plan was to stay till New Year celebration. Full stop. Our plan was to stay till New Year celebration. IIT, you are supposed to reach by IIT if by whatever means necessary by 10:30 maximum. So he in his statement says that his plan was to stay till the New Year celebration, that is 12 p.m. 12 a.m. So on that event, what stopped them from seeking in permission from IIT authorities? The argument which has been made from the other side is this: look, this plan was to stay outside was instantaneous. My friend fell ill, thus we had to stay outside. I asked myself, my lord, if my friend was ill at 10:30, why did not I leave the pub at 10:30? I may not go to the IIT because probably in some way I am trying to help my friend. Why didn't I book the hotel at 10:30 or go to the hotel at 10:30 or at 11 or at 11:30? I go to hotel at 12:30. So this entire argument that the plan was instantaneous, I had to survive, I had to take care of my friend, and for taking care of my friend, I had to book the hotel. In my humble submission is erroneous and probably alien to the facts. What I rather submit is that their plan was all throughout to stay outside the IIT campus till New Year celebration. At least it is coming out from his own statement. And all of them agreed to that. Petitioner number 2 and petitioner number 3. When petitioner number 2 fell ill at 10:30 p.m., petitioner number 2, he was in his senses. They determined we will go back to hotel. These 2 girls who were there, they at that time determined we will go back to hostel. These 2 fellows says we go back to hotel. These 2 girls says I will go back to hotel. Sorry, hostel. Somehow in between they changed their mind. Now, in my understanding, my lord, that decision of them of not going to hotel is very crucial. Sorry, not going to IIT hostel was very crucial at this point of time. That shows a negligence on their part. I will demonstrate how, my lord. For instance, my lord, if Vamsi was actually feeling, maybe he was feeling unwell, petitioners could have taken him to an hospital at that time at 10:30. 11, he was vomiting. He was in inebriated state. What they do, they put him into an hotel. Unfortunately or whatever, that girl stays there. Now, when that girl required a medical help, the petitioner number 2 was in an inebriated state. Their decision, thus, when IIT says that you have demonstrated inappropriate behavior, and you have risked the safety of other students is this. Petitioner number 1, petitioner number 3 were in their senses. 2 admittedly was not in their senses, not in his senses. They could have taken him to hospital, could have taken a better decision. They did not do it. All of them thus were liable for the negligence which has been caused and the indiscipline which has occurred. Now, my lord, point 3, which I have seen, which I have shown yesterday, they all were underaged, apart from petitioner number 3, and were involved into drinking. They gone into an alcoholic party. They consume substantial quantity of alcohol. Point 3, which I have shown, how the alcohol and how much quantity that my lord has seen, how it has been mixed. Because they were, that is the reason there is an age regulation. While in Assam, there is an age regulation of 21 years. Sometimes they have consumed whiskey, then mixed it up and all that, and that has happened. Thereafter, my lord, another important point, at 10 to 10:30, petitioner number 2 started feeling uneasy and vomited and was in inebriated stage, admitted position. He was not able to hear anything, but he was saying, I had read that statement, my lord will remember. Others have also stated that he was drowsy. Mostly because of the alcohol consumed, and requested petitioner number 3 to arrange to stay outside the campus. Purportedly, petitioner number 3, who was on his senses, however, chose to willfully neglect institute rules. Petitioner number 3, on the request of petitioner number 2, who was in inebriated state, agreed to his decision, his request. That way, it led to this situation. It starts from there. That is what I understand. It added up by Deepika and Aishwarya joining them. Rules exist to, that is the reason, my lord, rules exist in an academic scenario to probably carve such kind of a situation. If you do not follow rules, being an underage drinking, my lord has seen how it is a problem in India now. I don't want to elaborate that part. Thereafter, my lord, what has happened? Petitioner number 1 and late Aishwarya decided to went back to campus, but as their statement, but they ultimately decided to stay back. When they were aware that here, my lord, one important point comes into picture. All the petitioners were aware that IIT helps in such kind of a situation. Now, for a moment, my lord, I will take my lord to my affidavit and show page number 106 for a moment. My lord will take my affidavit of which I filed in my WP. Writ petition, page number 106 for a moment, my lord. In 17. Para number 16 start from page number 106, my lord. 106. Writ petitions affidavit which is filed in the writ petition, my lord, not in the IA. The continuous page number will be page number 106. It starts. Yes. My lord will turn to, I'll just show the relevant part. 107 is the relevant part. Parawise statement 107, my lord will say, IIT has made categoric submission. The deponent further states that institute authorities has always acted promptly in the past in protecting students and safe return to them to the campus, even in odd hours, whenever they had an information regarding students facing any kind of trouble. For instance, Guwahati authorities extended immediate support to bring back 7 IIT-G students detained in Goreshwar police station in 18 and 19 July 2022, when the complaints were received from the local police station that some student drank and created nuisance and disturbance to the local people in the visit to the Bogamati picnic spot. It is not that there was no instance, and this is not known. These people are from the 4th year student, my lord. This instance was known to them. IIT always helps, but not done. I will proceed further. Thus, my lord, even though petitioner number 2 was unwell and in inebriated stage, other petitioners, that is 1 and 3, fully aware of IIT has a functioning hospital inside IIT Guwahati. 2 was unwell, inebriated stage, could not figure out what has happened. There could have been some kind of untoward incident could have happened to 2 also. He was underaged. They were aware also if there is a hospital inside IIT campus. They did not go back. For some unexplained reason, they decided not to go back to the campus and stay out in a hotel in the city. This goes to show their action in the night of 31/12/2023 not only posed a risk to the health and safety of themselves and their peers, but also amounts to inappropriate behavior. Thereafter, my lord, this decision of petitioners 1, 2, 3 to stay back at the hotel was voluntary decision, and it is not somehow or other related to petitioner number 2 getting or reaching in an inebriated state. Why? As I told little earlier, that had the decision was prompted because of the inebriated or the unwell which petitioner number 2 was, they would have left the party, no, my lord, at 10:30. Take him to the hospital. They did not do it. Thus, the decision to stay was voluntary. The breaking of the law was intentional. And with all, that is the reason the consequences of law has to follow upon them. Further, my lord, it was, yes, Srinivas, my lord had seen that Srinivas had booked 2 rooms on 31st. Now, he says that he has done it by mistake. Generally, if 2 boys were supposed to stay outside, 1 room was enough. What I am trying to reach here is this, my lord. If somebody is in his senses, he might not have done it. So this goes to show that the argument been advanced in the statement that Srinivas is saying that I was also in an operative state was not right. Probably, my lord. He would have seen while booking that there is 2 rooms. I'm clicking at 2 rooms. Default setting is always 1. Let me proceed further, my lord. Now, as per the statement of petitioner number 1, only boys were discussing about staying back in the city. She and girls decided to come back to the college. In the meantime, Srinivas booked 2 rooms. All wished each other Happy New Year at 12 a.m. and came out of pub. After they came out of the pub around at 12:30 a.m., while coming out, petitioner 2 vomited. My lord has seen that. He himself says. He vomited in the lift and was feeling extremely inebriated state. At that point, the petitioner decided to head back to the hotel and chooses not to seek help from the IITG authorities or arrange any basic medical help for the petitioner number 2 also. Had they would have done either of them, that either they would have gone back to the IIT or would have got some help for respondent number 2, sorry, petitioner number 2. In that case, my lord, 2 situations could have been avoided. First, this inebriated stage could have been taken care of, and maybe the late Aishwarya would not have met that unfortunate end which he has met. It is an admitted position that he was completely drunk on the night previous. He did not know. From his statement I have read, there is nothing mentioned what once he has reached to the bed, what has happened. At some, to my understanding, what he has stated, when he got up at 7:30, she was making some sound. Might be she would have been making this sound longer or longer before.
See,
Nobody knows
the
it.
issue is this. Now what we have seen is they've gone out, they've had some drinks. One was not well. They went to hotel. That aspect now we are very clear on that.
My lord.
Now
My lord,
the issue is
on that I will come to the next point. My lord, I'll come to the next point. I am obliged, my lord. Thus, this, my lord, but the point which was canvassed that it is a hostel level violation. Argument was canvassed yesterday that it is a hostel level violation. That probably is not correct. I will show now how it is not correct. Here, what has happened? These 4 people are senior most students in the campus. Whatever in the undergraduate program, at least, they are supposed to show thousands of other boys are there. Their act and ultimately death of this one girl has caused a major disturbance in the institute. The congenial education environment was disturbed because of this major act of indiscipline. Therefore, IIT authorities, in their own wisdom, has decided to invoke 4.3.3. I will also show why hostel regulations are not at all comes into picture. Hostel regulations are only for the hostel. If you have made anything inside the hostel, this act transcends. Let me now show the regulations for a moment, my lord. My lord will see. My lord will our code of conduct, my lord had seen last. Yeah, one line from the code of conduct, and I'll in the affidavit in reply rejoinder probably, my lord, that submitted the code of conduct. Affidavit in reply. Let me read one line from the that rejoinder, my lord. My lord will take out the code of conduct for a moment. 189 was the page number, probably, my lord. Thank you. 189. My lord will see in the introduction. Second paragraph I had not read. Let me read that second paragraph now. Interpretation of provisions of the within the code of conduct of students may be requested by contacting the Dean of Student Affairs. Thus, the Dean of Student Affairs is the ultimate interpreter of the code of conduct. No interpretation, apart from the interpretations which are being taken by Dean of Student Affairs, can be advanced. That is to say, if you have not challenged the repugnancy of the ordinance, you cannot take a plea. A Dean of Student Affairs in their wisdom has not taken a proper decision, has invoked 4.3.3 for a different reason. Not that, you cannot do so. Apart from the fact that 4.3.3 is attracted here, otherwise also. But how the code is to be interpreted, that is left to the disciplinary authority only. The disciplinary authority's interpretation will be bound to the petitioner. And that is the interpretation which will sustain. That is my submission, point number 1, my lord. On this, on the code's interpretation. The argument made is that the interpretation is not correct. They should have read it in different manner. Not true. Now, all this brings to 4 facts, my lord. First, did not seek prior permission, did not make entry in the security decks, indulge into underage drinking, exhibited inappropriate behavior under the influence of alcohol, and stayed out overnight. Therefore, my lord, in this backdrop, respondent authorities decided to conduct the investigation by invoking provisions 4.3.3 of Ordinance of Code of Conduct. Accordingly, the matter was investigated by Student Disciplinary Committee. Now, let me read now for a moment, my lord, 4.3.3 before going to the other interpretations. But here, my lord, we'll also see 4.1.1. That, my lord, will find in the, I'm sorry, my lord, probably it will 1.1, 4.1, it will page number 194, my lord. There, 4.1.5, next page, that is in 4.1.5, my lord. My lord has seen clause 6 of the statute, my lord will remember. Yeah, I had last I had read that how the statute has to be that the power is there to the director to make any committees, appoint any committees. Statute, my lord, has clause 6 as my lord has seen in our statute. Now, my lord will see 4.1.5, last line. In addition to the chairman of the respective committee may invite other persons to be associated with the proceedings in a particular case if their participation is considered necessary in disposing of a matter. My lord will just remember these lines. I will come back to this. How this has interplayed and how we as an institute function, that has a bearing with this. Now let me read 4.3.3 for a moment. I'll address this little bit more when I address the fact-finding committee. 4.3.3, my lord, institute level violations. 196. Violations at the institute level include those issues pertaining to Indian Penal Code within or outside the campus. Comma, my lord. It is not and thereafter. It is a comma. And the comma has to be read as or in this case. I will show how. Or those that can affect the IITG community at large. Or those that can affect the property of the institute itself. Here, what has been done, my lord, the argument which has been advanced by the petitioner side is to try to read the comma as end. And the argument has been made without reading the next line that look, only violations which can SDC can draw cognizance is only for the IPC violations, which is absolutely wrong interpretations. With all due respect, my lord, I submit this. The power of interpretation of the clauses remains with the disciplinary authority only. I've shown that earlier. Now, if it doesn't, let me presume that against myself that it is IPC. My lord will see the next line then. For all such major acts of indiscipline which may have serious implications on general body of students. So if you want to cover the indiscipline part, then that after comma, those lines will come into play, my lord. That can affect IITG community at large. So, my lord, let me read it now completely with the or, and the meaning will follow. Violations at the institute level include those issues pertaining to Indian Penal Code within or outside the campus, or those that can affect the IITG community at large, or those that can affect the property of the institute itself. For all such act of indiscipline, which may have serious implication on the general body of students and which may warrant a uniform and more formalized nature of investigation, SDC will decide to investigate the allegations and recommend disciplinary actions. The committee may co-opt other members if they deem fit. On a case-to-case basis, charges recommended by SDC, my lord will mark this line, this is very important here. Charges recommended by SDC shall be referred to the chairman, Senate for approval, and will be reported to the Senate upon approval. The charges will be intimated by HOS essay to the concerned people. Now, let me break it down, my lord, and let me make two arguments here. My first argument is this. I have demonstrated from the facts how this is an act of major indiscipline. And if in case of an act of a major indiscipline, the power is there to, under 4.3.3 of the institute, to constitute an SDC. It is nobody's case that this is not a major act of indiscipline. At least this is how I look at it. In such event also, HAB does not have a power. That is 4.3.1, my lord. In the previous page, my lord, we have seen that it was read yesterday to say that it is a hostel level violation. My lord have seen that. Let me read that part again. To deal with disciplinary matters at this level, there will be two committees, namely Hostel Disciplinary Committee and Institute Level Disciplinary Committee. Violation of general rules issued by the Hostel Affairs Board. General rules issued by the Hostel Affairs Board by the hostel resident will come under the purview of Hostel Disciplinary Committee. It is not this case. This is not the case. These matters are minor in nature and restricted to the particular hostel. It has inter-hostel, inter-campus implication. The SDC will deal the matter and give appropriate punishment. Now it changes. For matters which have implication across hostels, shall be referred to the institute level institute hostel disciplinary committee. These matters mainly related to hostels only. Then it comes other matters. My lord has seen other matters. Other matters which have major implications at the institute level shall be referred to the student disciplinary committee of the institute. See below. These lines, in my lord, in my humble submission is this. This puts a clear case that why IIT invoked 4.3.3. In the opinion of IIT, this is a major act of indiscipline. And the interpretation which has been taken by the Dean Student Affairs will be binding in this case. Only question which now remains, whether the proceedings of SDC are been conducted in a manner as been prescribed in this statute. If that I can satisfy this honorable court, and if there is no prejudice has been caused because of some alleged violations of natural justice, this honorable court may not interfere. This is the two things which I have to show this honorable court now. My lord, now will come to my affidavit, my lord, again, affidavit. No, no, thank you. Let me just take my lord, to the SDC proceedings. My lord, in the original, in the record, my lord will find the same thing. The originals are there in the record. It is arranged date-wise, my lord. How the date-wise thing has happened, it is arranged. Yeah, deeply obliged. I am putting the fact still, my lord. That is now. First is 5/1/2024. The meeting of the Student Disciplinary Committee held on 5/1. My lord has got that line. Let me read forward. The case to investigate the unfortunate death of IIT Guwahati student on 1/4/2024 and the violation of code of conduct by the 3 other students who are associated with the incident. The following students were involved. 1, 2, 3. Name of the deceased student is late Pulari Ashwarya. Roll number such and such. Department Electronics and Engineering, Tisang Hostel. Complaints. The competent authority has decided to investigate the sequence of events that led to the unfortunate death of late Pulari Ashwarya on 1/1/2024 outside the campus, and the violation of code of conduct by 3 other students who are associated with the incident to get insight into the circumstances leading to this great loss. Therefore, the 3 students who were present along with the Ashwarya on New Year's Eve were called to SDC meeting to investigate the complaint. Next page, my lord. Deliberations. My lord, while reading, my lord will keep in mind, these people are, I had read my code of conduct first page. These people are generally not from legal background. They're professors, they're masters in their own field, and our code of conduct protects them. Deliberation. Miss Paduki Deepika, Mr. Peresu Srinivasan and Jatehu Vamsi were given opportunity to explain before the committee about sequence of events, including their travel from hometown onwards, that took place until the death of Pulari Ashwarya. That is the reason my lord will say in the statement, they have stated everything that way, missing certain important parts. After listening to the detailed explanation, committee asked several questions to understand the details of the incident and circumstances leading to it. All 3 accepted, my lord will mark this line. All 3 accepted that they had violated several clauses of code of conduct. I have shown it from their statement itself. Paduka's statement, my lord will see, Srinivas and also this guy has accepted that they violated the code of conduct. Admission on their part. Violated several clauses of ordinance of code of conduct of the institute and have acted in very irresponsible way. At the end of the discussion, the students were directed to submit an individual written statement regarding the incident. As they submitted the written statement to the committee, thereafter recommendation. After detailed discussion and deliberation, Student Disciplinary Committee opined that Paduku Deepika, Peresu Srinivas and Jathui Vamsi had violated several clauses of code of conduct and of the institute. Further, many aspects of the incident that led to the unfortunate and untimely death of Pulari Ashwarya were still unclear and require further investigation. Therefore, SDC recommended first, a fact-finding committee. Podugu, Deepika, Perusu Srinivas and Jathui Vamsi were suspended and they were been asked to vacate the institute hostel and go home. Further meeting ended with the vote of silence to the GA. So on that day, on 5/1, even though they have submitted their written statement, many questions were put to them. The details which were not there. And my lord will see, I will not trouble this honorable court with the fact-finding report that is there already in the original record. My lord will see in the original fact-finding report how the statements have come, how the other details are submitted. It is there, my lord, in the record, in the last probability, or say it is there in the date-wise EA, my lord. I think next is fact-finding committee report only, to my understanding. No, the original record. But it took that quote for us. Affidavit quote for us. Annex for but
Have you given a copy of this to the petitioner?
in my
Fact-finding
affidavit, my
report.
lord, in my affidavit, I have quoted the entire, the recommendations have been quoted. That part I can take this.
No, no, recommendations fine. Have you given a copy of this fact-finding report?
This was discussed to them, my lord. I'll take this quote through. This was discussed with them. That will I'll also show it from the record.
No, no, I'm asking you one question. Have you
My lord,
furnished a copy?
the physical copy, to my understanding, no, but the report was discussed to them and there was no request ever made by them to give the copy. Have they would have made the request before the concerned authority, the authority would have given them. There was no request. If you require a document in a disciplinary proceeding, you may have to make a request. Now, my case is this, my lord, that this report, firstly, my lord will see the report. The report is there. Whatever is there in the report are from the evidence which they have given, the conclusions, and not from somewhere else. Point one. Point two, these reports had been discussed with them. They have been put questions based on that report itself in the final hearing. So they have been made aware of the contents of the report. I humbly submitted it in this way. Thus, by the law laid down in the Supreme Court and ultimately followed in the Yuvraj Siddharth matter by this honorable court, there is no prejudice been caused. I will demonstrate that judgment also I have. The law of natural justice is this, my lord. Maybe you require 10,000 documents. But if that non-providence of that document should cause you some prejudice. Now, my submission is this. First, they did not ask for the document. Two, the document was discussed with them. Three, the contents of the documents are not from some other documents, from the documents which they have only given, and the submissions have been made. Entire, if required, my lord, the videography. In the fact-finding report, my lord will see the second paragraph, probably, if I am not badly mistaken. It is written that the entire meeting has been videographed. If my lord wants, I can ask IIT to produce the videography of that entire proceeding before this honorable court. So it is from their discussion itself, the report has been prepared. The recommendations, the observations are everything. Leave aside everything, my lord. Let me leave aside everything. It is admitted fact, they have not made the entry. The charge number 1 goes from there. Charge number 2 is that the hostel, they have also not taken. Charge number 3 is that the health and safety. I have demonstrated that had they would have taken that correct decision, the negligence is beyond questionable, man. Beyond questionable. On such event, charge number 3 and 4 also get established. Leave aside the report for a moment also, that because of the admission made by them in their reply itself, my lord, in the reply they have admitted. If the reply they have admitted to the charges, nothing remains. Let me now, my lord, take to the, for a moment, let me just show one part. There was an argument made yesterday also that this fact-finding committee is alien to the report and this fact-finding was not, how could they do it, some fact-finding committee and all that. Let me now demonstrate. So, my lord, I'll see in 4.3.3. 4.3.3 says that if anything I have to do as an SDC, I have to take consent from the chairman of Senate. My lord will remember, I had submitted yesterday that as per my act, the chairman Senate is nobody but the director. Director was, my lord will remember, I have also stated, he was, on that particular time, he was out, somebody who was outside. He was not a regular director. But as per clause 6, 19, sorry, now what is it? Statute, no? Huh? 19.6, 19.6, 19.15, what? My lord, 1 minute, yeah. Yeah, 9.15, the statute. 9.15 of the statute, my lord will remember. Director in its discretion.
Statute?
9.15, 9 subclause 15. Page number 113.
Yes.
9 subclause 15. 9 subclause 15, my lord. The director has the power to constitute committees as he may consider appropriate. This clearly shows from the note sheet that the fact-finding committee was approved by the director. This seals that argument that the fact-finding committee was not properly constituted and whatnot. Apart from that, my lord, I have shown 4.4 the powers in 4.1.5, the chairman powers in the statute in the ordinance, where he can co-opt members if they want to. I've also shown 4.3.3.
Just one minute.
Mr. Chaudhary was supposed to give a reply, but then today original records have also come. So my friends have requested me, they would like to verify things from the record, and thereafter, my lord, an appropriate date may be fixed. So, my lord, we have agreed on a mutual date after 9th of August, preferably on 12th of August, if my lord so feels.
Okay. Preferably on
12th of August. 12th.
I can request made by the parties. This long, 12th of August.
And then, my lord, we would, on 12th, I believe, original record will not be required.
Monday, it will be Monday. I don't know. It will be 12th.
In
My lord,
any case, today I don't think I
I
will be
know, my
able
lord, I was told lordship is not feeling well. So, my lord, and same is the case with me too, my lord. I also want to be relieved. So, when I realized they are verifying things from the record and they are also not in a position, we agreed on a mutual date. So, my lord, let it be. If 12th or 13th, whatever, my lord, we will make arrangements. We will adjust accordingly. Let it come on 12th, we will adjust.
Yes, sir. Much obliged, sir.
I beg apologies, my lord. I was not aware that my lord was unwell. If my
I'm
lord
having a horrible toothache. Painkiller is not working. That's not working at all.
my lord, can I then do one thing just to I will summarize my argument, and probably by tomorrow morning 10:30 I will file a short. It is already ready at my just little modify it, and I'll file it, my written submission. I'll not trouble the lords. Yeah, that will cover. If my lord only to cover, my lord is unwell. I was unaware, my lord. I'm sorry, my lord.
No, that's fine.
I'll
Thing
summarize
is-
my argument, my lord.
Thing is, I'm trying to dispose this matter.
Exactly, my lord. Lordship is
The thing is,
taking the pain. Yes.
this is becoming very unbearable. Very
I'll summarize, my lord, now. Because to the point, I will not be trouble. So let me just tell this, my lord, that on after 5-1, what has happened? After 5-1, my lord, so after 5-1-2024, when the SDC was convened and SDC come to the finding, my lord has seen that finding, what the SDC has said. Why it was been said, I have also demonstrated it why it was been said, because the records were not, the details were not coming out from them. There are a lot of questions. Why they booked, there are a lot of things, as I've said, intentions were not coming. Malad will also appreciate this. These two documents, which are now been part of the petition, and on the strength of which the petitioner is claiming that she is innocent and they are innocent. That is this autopsy report purported, and one that letter. These two documents, admitted position is this, my lord, these are not produced before the disciplinary authority. Thus, my lord, I will request this honorable court not to look into this document, because the disciplinary authority was unaware of this. This autopsy report, my lord, but the autopsy report says that she died from pneumonia. Why IIT investigated this matter? Why IIT was trying to find out what has happened? This autopsy report was not brought to the notice of SDC ever. Secondly, that letter, because what has been my instruction is this, that the parents of the late Ashwarya, they came and they registered a severe protest in the IIT also because of the death. This letter, which is been given, I'll just tell the court what is the annexion numbers. First annexure is, my lord, page 2774. Writ petition page 74, my lord. Page 74 is my lord has got. I'm now summarizing, so I am jumping, my lord. So this page 74, my lord, that is death of Pulori Aishwarya D. Ravi such and such, such and such. I am sad to inform such and such that I have received a phone call from my daughter Aishwarya's friend that she was suffering from the severe breathing problem and was rushed to GMCH hospital where she was declared brought dead. I came to Polton Bazar PS today. I don't have any suspicion on anyone and I do not want to register any complaint case right now. This document has been produced in the writ petition, was never given to before the SDC, the disciplinary authority. Second document, my lord, is the death certificate. That's the purported, in my opinion, it is purported because the maker of the document has not been examined. My lord is aware of the rules of evidence. I do not want to trouble this court with the rules of evidence. I have that with me, but how a document has to be proved. Now here, this document has been shown, that is the final opinion, 76, my lord, autopsy report. Autopsy report, one word, I'll just read and one line probably, which was been read yesterday again. Let me take that indulgence, my lord. Last line in page 77. 76, it starts the autopsy report. That is basically, it is basically type copy, my lord. The original report, I think petitioners can produce it, whatever, if they have it. 78. Yeah, that is a copy, original copies. Xerox copy was 77, the last line, my lord. It is not a conclusive opinion. Let me start by saying this. Had this guy would have been examined, we would have understood the veracity of his opinion. Let me by starting say this. Female would appear have died by bilateral lobar pneumonia. My lord has seen. This two document has been shown, and on the strength of this, the argument has been made, look, I am being exonerated. But these IIT people are so evil that they are prosecuting me for the death of the student. For an in number of time, there is no police case, there is no autopsy report, nothing. I am being clinched. But I am being hounded by these IIT people. That is the argument which has been made by in this court, my lord. And the petitioner's case is this, that they have been exonerated. They have no role to play in their death. I humbly submit before my lord this. These two documents were never brought to the notice of the respondent authority. Now, question may arise. The petitioner said argument can be one, that I did not have the documents copy with the custody of the documents was not with me. But the responsibility was, if you want an exoneration, the responsibility was on you. If you want to take a favorable view, if you wanted the disciplinary authority to take a favorable view, then you should have produced this document to the disciplinary authorities. She was apparently, she was their friend, childhood friend. There is a statement made in the writ petition, childhood friend. Now, two, what happens here, my lord will see. My lord have seen my ordinance. In clause 6 of my ordinance, there is a provision, which I will like to take one line of the ordinance, my lord, because it has some relevance here. Why this clause is there? IITG has put up a clause in the clause 6, my lord. Page number 199, probably it will be, my lord, of the continuous page number. Yes. Student can appeal to the appellate authority against any punishment imposed upon him or her. He should appeal within 2 weeks from the proper justification of appeal. Now, here, what the petitioner has done, petitioner has approached this honorable court before filing this appeal, before the statutory right which is there. Now, appeal provision is there in 4.4, my lord, hierarchy. That is in page number 1 196, that 4.4 is there, 196. So all disciplinary matters of SDC, the approving authority is Senate chairman, appellate authority is board. My lord is seen. Now let me understand this, my lord. This document, if let me presume against myself that these documents were not there at that point of time, let me presume this. That is the precise reason you should have filed an appeal immediately before the appellate authority. And appellate authority would have taken consideration of it. This honorable court is not an appellate authority. This honorable court does not sit as an appellate court over the disciplinary authority. This honorable court is only looking whether the procedure of the law has been adhered or not. If you wanted to take any plea on based on additional evidence, that could have been easily done before the appellate authority. That is my submission, my lord. Now, my lord, we'll see after they did not submit it from 5-1 first hearing till 22/4/2024, the last hearing, they did not submit it. One more argument what has been canvassed yesterday, what that midsem was there. My lord will remember that IITG suspended, they did not allow us to appear for the mid-semester. Now, dates of mid-semester will be important, my lord. The submission which was made by yesterday was 24/2/2024 till 1/3/2024, mid-semester was there. 24/2/2024. Writ petition, Roman page number, writ petition, there is a table, my lord, yeah, in the list of date is there in the writ petition. That is 5, Roman 5. That is in the first, yeah, they have given a list of dates, my lord. List of date is given by them. Has already seen that list of date? Roman 5.
Roman 5.
Roman 5 in the initial pages, my lord. That list of date is there. Initial page of the writ petition, my lord.
Oh. Roman 5.
Roman 5, my lord. After the synopsis, my lord, there is list of dates. The synopsis is Roman 1. At the first page of the writ petition, my lord. First page of the writ petition is the Roman page 1. Then Roman 2 is the synopsis ends. 3 is the list of date. 4 is again list of date. 5. 5, my lord. See the top of the page. 24/2/2024 to 1/3/2024. Mid-semester was there. Plea has been taken that I am not addressing this. If this honorable court wants, I will address the on suspension part again. But I think my lord has understood 5.9 how it plays out. Suspension part I am not addressing, but I can address it if required. Now, mid-semester, my lord, their argument is this: IIT intentionally debarred us. The suspension was made. We did not, so that we did not, we could not participate in suspension. We are been suspended, cannot participate in the mid-semester and all that. My lord will see the entry number when they have communicated with the IIT thereafter. After when they have been suspended, when is the first communication? That is 22/3/2024. Sorry. Yeah, sorry. 27/3/2024, my lord. If I'm not badly, let me just take it out.
27.
1 minute. Let me just take it out. The page number, my lord. I'll appropriately take the page number. So, though they go for the from the campus on 8/2/2024, they first communicate on page number 43 on 16 February, where they write they have done some plantation work and all that. Page number 43. My lord had seen yesterday, day before, each and every pages was, my lord, were taken out. taken. So they say she has done some plantation work, distributed books in the memory of EA. Was there any prayer for allowing them to attend the mid-semester examination? In my humble submission, no. Secondly, my lord, thereafter, the next letter which comes from them is 27 March, page 46. And it goes on. What they are writing in those letters are their anxiety to complete the disciplinary proceedings. It goes on. 46. I don't want to trouble further, but it goes on similarly. What they are writing, sum and substance is this. They are in agony. You complete the disciplinary proceedings earlier. But as an IIT, we have to follow the rules. Our director was not there. I have shown it. If the court permit, I would have gone page by page and content by content what is written there. But sum and substance is this, that they did not, never made a specific prayer for mid-semester. They raised the issue that I have missed the mid-semester. Now let me ask myself, this honorable, they could have approached this honorable court before mid-semester. If they have approached, the fact of the matter is this, when they approached before this honorable court on 26/4/2024, this honorable court permitted them to appear before in the end semester. Now, they did not appear in the mid-semester at all. Neither there was any prayer, neither there was any specific representation. Neither they have approached this honorable court. Now they are making an argument that even though we have not participated in the mid-semester, even though we have not participated in the continuous evaluation process, you give all marks to me. That argument in itself is fallacious, my lord. To my humble understanding, the laches on their part cannot be ascribed to the respondent. Respondents are supposed to follow the letter of the law, and the letter of the law in this case has been followed by the petitioner, by the respondents. If as the need if it rise, I will show point-wise point how the disciplinary proceeding has proceeded. But there is no delay on our part because we have to take approvals. Because if you have not taken approval, the argument will be, boss, you have not taken approval. So I'm sorry, my lord. So that you have violated your provisions. 4.3, there is a mandatory approval is there. I have to take an approval. Now let me come back, my lord. What happens thereafter? Fact-finding committee sits. Fact-finding committee submits its report as per this on fact-finding committee. My lord, 1 minute. So thereafter, my lord, fact-finding committee submits its report on 22/3/2024. No prayer before anyone, no prayer before court to allow them to attend the mid-semester or others. This honorable court in other cases.
When did they submit?
The report was submitted on 22/3/2024, my lord. To the SDC. SDC meeting. Now, what happens, my lord? This line has been picked up. Again, let me just address this line and probably I will address the Shoko's notice issue also. So what happens there? On the fact-finding, before the fact-finding committee also, these two documents of autopsy report and the letter of father is not submitted by them. So what happens, fact-finding committee? They discuss the entire matter, the documents which have been submitted by the petitioner and taken into record, and they go through, they formulate the report, the reports are there. The relevant part of the recommendation is there in the EA also, our reply also. Now let me read after what has happened after fact-finding committee. So fact-finding committee submitted its report on 22/3/2024. Immediately thereafter, on 26/3/2024, the SDC sits. Let me tell this, my lord, SDC can sit as number of time as it wants. Because it is completing a disciplinary proceedings, it is not required to hear the matter in one day and without following the letter of the law to come to a finding. SDC is not required. It is not permissible. So page number 144. 144, my lord, of the writ petition. Hundred and 44 of the not the writ petition, my lord. My affidavit in reply to the writ petition. 144. The content of page number. At the same time, my lord will see my petitioners have attached also. There is an email from the SDC that they should attend this meeting of 26/3. That is page number 45. Yeah. So this meeting happens on 26/3/2024 when this report of fact-finding committee report has been discussed. Let me read that again, my lord. Investigate the unfortunate death of an IIT student, such and such, following student. Case history, they repeat in the SDC meeting, such and such, 3 students, such and such appeared before the SDC and were given opportunity. Again, my lord, they were given multiple opportunity to present their case. Matter was asked several questions. At the end of the discussion, petitions were directed. Submit the written statement. Proceeds. Following recommendations were made. As per the information, next line, my lord, thereafter. As per the information received from the hostel staff, student vacated the respective hostel. Here also, my lord, IIT has given them enough time. They have not thrown them away. After 31st of January 2024, IIT has not thrown them away. You said you go out to the hostel. No. As much of that one time they wanted, IIT has given them extension. IIT has not behaved in a high-handed manner in this case, which has been projected. There's some sort of an evil organization who hounds students and make them suffer for their EA. Not like that, man. We have helped them arrange counselings, undeniable fact, given them multiple opportunities to stay in the hostel, then EA. Arams, no problem. So thereafter, my lord, he records. Further, 3-member fact-finding committee constituted with the approval of the competent authority investigate the matter. The detailed report such and such 22/3/2024 was submitted by the fact-finding committee to the chairperson. The fact-finding committee interacted with the students during that investigation and understand the details of the case. Second time interaction. Second opportunity of being explaining their case. Thereafter, the deliberation happens. The SDC on 26/3/2024 discussed the report submitted by the fact-finding committee. After detailed deliberation, student disciplinary committee found the students such and such guilty of the following subjects. Now, here, all of a sudden, a word guilty they have picked up. And it has been thrown at the court to mean this shows the preconceived mind. In my humble submission, it doesn't mind. This is a prima facie observation in my humble submission of the disciplinary authority. That is the reason, my lord. Maybe their drafting there is some error in the drafting. I will demonstrate that also. But there is error in the drafting. Maybe they have not used the word prima facie guilty because they were proceeding on the material which is before them. This 2 material was not before this honorable, the learned members of the disciplinary committee, my lord. Then these charges have been drawn up. These charges were thereafter, violations are also drawn up and they were being communicated by 5/4/2024. The recommendation of the SDC are there in the page number 147, my lord. What the recommendation they have made. See, my lord. From there, it becomes clear. It has recommended filing charges, issuing show cause notices to the then why the institute cannot impose disciplinary sanctions on them for violating code of conduct. Further, such and such are given sufficient time for 15 days to submit the written statement to the show cause notice. Vamsi such and such be given chance to present their statements to the SDC after submitting their reply. Therefore, my lord, the word guilty has been given an undue importance in this entire conversation. To mean that they have expressed their mind. To my humble submission, no, my lord. I humbly submit it is not. Now let me just show one more page on the writ petition, page number 45, my lord. Apparently, petitioners may help us to understand what is. Petitioners were also invited to that meeting of 22nd March by the page number 45. You see, you are directed such and such, such and such, such and such, asked, my lord has seen, required situation, you may join. You are required to join the institute only after being asked. I do not know whether they have been here, but they were also been asked. Even though they have not joined also, there was nothing in this meeting which can be said that they have that is what I'm saying. That petitioner can only submit. I'm not
allowed to join, my lord.
I do not know
That
whether
we did not join.
allowed communications were there, allowed, not allowed. I'm not on this. What I'm trying to tell this honorable court is this, that the entire guilty word which has been used to mean that they have shown the preconception of my mind is not correct. Thereafter, my lord, the show cause notice 5-4 was issued to them. My lord has seen the show cause notice. Page 49 on the writ petition, they have shown the show cause notice. So here, while issuing the show cause notice, I humbly submit that letter of the law, that is 4.3.3, has been followed by the institute again. After these charges were framed in the disciplinary hearing, disciplinary committee on 26/3, necessary approvals were taken by the competent authority, that is Chairman Senate. And after the Chairman Senate approved it, this show cause notice at page number 49 was issued. Let me read. Charges recommended by the SDC shall be referred to the Chairman Senate for approval and will be reported to the Senate. Upon approval, the charges will be intimated by HOS SA to the student affairs, to the concerned people. Same thing has been done. Letter of the law, my lord. Maybe there unintentionally, maybe, my lord, some time has been taken because of the administrative difficulty which was there. The Chairman Senate we do not had the full-fledged director on that time. Thus, the time was taken. Now, if my lord turns to page 50 of the writ petition, petitioner side has shown the word guilty and that line. I do not want to go there further. Above violations resulted in the loss of life of the student, that was been shown yesterday. To say, look, everybody has exonerated us. You are investigating the death. Humbly submit, those two documents were not there. See the paragraph 3, my lord. Therefore, you are hereby to issue show cause notice as to why a proper disciplinary proceeding should not be instituted against you for committing above gross misconducts which have resulted committing in violation of above mentioned clauses of ordinance, which is unbecoming of a student of IIT Guwahati in terms of ordinance such and such, and further as to why disciplinary proceedings sanction should not be imposed as per Rule 5. Thus, my lord, the disciplinary authority had never expressed their mind. They were proceeding because these are all prima facie observation of the disciplinary committee. For formation of charges, my lord is aware, in criminal trial also, for formation of charges, the court derives a prima facie opinion. All show cause notices are issued on basis of prima facie opinion, my lord. Now let me show the last year, the show cause, how that thereafter what has happened. They have submitted their reply. The reply, my lord had seen page 52 reply. It was been stated. Let me just show one part of the reply and probably, if required, I'll take this code, trouble this code a little bit more. Page 52, my lord. After point number 2. Point number 1, she says same thing. She do not deny that she did not say that, yes, I have admitted. Sorry, I have made an entry. She gives an explanation, ki, look, car did not, that he opened the door, I go. So this is an admission on their part. Second, she says, I acknowledge that I have violated hostel regulations by failing to notify the authorities to seek permission for our overnight absence from the campus and regret for not doing the instance. I offer my regret, heartfelt apologies for the consequences of my decision. There she is again stated that same thing. I did not want to, my lord can go through the reply and my lord will be able to understand. There was an admission on their part that they have violated the IITG regulations. That regulation consequences cannot be limited to the hostel, that they are not returning to the hostel. The consequences was that somebody has died. Consequences was that some underage boy was, petitioner number 2 was in an inebriated state. That is the reason this had an implication of 4.3.3 and not 4.3.1. Now, after this reply, my lord, IIT gives that their final hearing opportunity. That is, the final decision has been taken not on 26/4/2024, which has been again been portrayed by this petitioner. That look, I got an order from the court, same day they wanted to somehow bypass it. They issued this order. No. On 22nd, that my lord will find in page number 148 of my EA. Continuous, my lord. What 148 says? So entire background has been given in 148, my lord. And they say, take out the judgments. Competent authority decided to investigate the sequence of events that led to the unfortunate death of late Pulori Ashwarya on 1/1/2024 outside campus and violation of code of conduct by 3 other students who were associated in the incident, and to get insight of into the circumstances leading to the great loss. IIT was always trying to understand what were the circumstances that led to this death, so that such kind of incident do not happen further. Therefore, 3 students who were present with Ashwarya were called on SDC meeting to investigate the incident. Such and such, then next para Podogu Deepika, Podogu Perusu Srinivas, Jatu Vamsi were called earlier to appear before SDC on such and such date and given an opportunity to present their views. After obtaining detailed explanation and cross-questioning the students and going through their written statement, the committee observed that many aspects of the incident were still unclear, and the written statement, due to non-submission of relevant documents, that relevant document will my lord will find in the fact-finding committee how documents have come. But some important document as per them, they have not submitted or whatever. Incident was not clear, and documents and decided to constitute a fact-finding committee to investigate the entire incident and suspend the students from the institute temporarily. The fact-finding committee met and gave another opportunity to the students through an online meeting on 28/2/2024, submitted a detailed report along with other documents related to the incident and few observations on 22/3/2024. Subsequently, SDC meetings were conducted on 26/3/2024 and deliberated the report submitted by the fact-finding committee. After detailed deliberation in the SDC meeting held on 26/3/2024, SDC recommended issuing show cause notice to the such and such person and following charges. I'm not reading the charges. My lord is aware of the charges. If my lord wants, then I'll read the charges. Shall I read the charges? Okay, then I'll proceed further. The above violation resulted to the loss of student. Again, here, my lord, I would like to point out this on this date also, that is 22/4/2023, the last SDC. These 2 document, autopsy report, and that was not there. Accordingly, a show cause notice, next page 150, my lord. Accordingly, show cause notice was issued to Podogu Deepika, Perusu Srinivasan, and Jatuhu Vamsi on 5/4/2024 and advised them to respond, if any, in a written format within 15 days. Opportunities were given to them to explain the charges, and proper opportunities were given. Podogu Deepika, Perusu Srinivasan, and Jatuhu Vamsi submitted their detailed reply to the show cause notice and requested for a hearing before SDC to explain the responses. SDC meeting was conducted on 22/4/2024 to allow Podugu Deepika, Peru Srinivas and Jatui Vamsi to explain their responses to the show cause notice. Committee asked many questions based on their reply to the show cause notice and also the observation made by the fact-finding committee, which were still unanswered even after submitting the written reply. Let me pause here for a moment, my lord. Therefore, I am saying that fact-finding committee's observations were discussed with the petitioner side. They were made aware of this. This is the observation which has come against you in the fact-finding report. What you have to say? This entire argument that the fact-finding report was not made aware to us, that the physical copy was not given to us, it is not correct. In my humble submission, because there is no prejudice has been caused to them. I will now demonstrate. Let me go further. Fact-finding committee which is still unanswered and after submitting the reply. Committee asked many such and such, and after submitting written reply, Mrs. Podugu Deepika, Peru Srinivasan and Mr. Jatui Vamsi failed to provide any clear answers to the show cause notice and questions asked by the committee based on the observation of the fact-finding committee. This goes on to show my point, my lord, that fact-finding committee was discussed, and fact-finding committee, my lord, will see the observations are not from some other documents which are submitted by them and the story which they have only said. After detailed discussion and deliberation, SDC unanimously agreed that Podugu Deepika, Perusu Srinivasan, Jathu Vamsi had acted in very irresponsible manner and their gross negligence behavior had led to sequence of events which finally resulted to a young life. The committee felt that the student failed to show basic sense of responsibility and care towards their peers and could not prioritize safety over careless alcoholic party enjoyment. Hence, SDC reaffirmed the guilty charges imposed upon them and strongly recommended following penalty. Penalty number 1, such and such are directed to undergo expulsion from the institute for a period of 1 semester. Now, let me just pause here for a moment and let me just show one just small fact and quickly show and come back. My lord, I have seen that table at 5.10. Now, there is something called rustication is also there, where entire course you have been terminated. Not done. They have been given expulsion from January 2024 to June 2024. Thus, the period which is undergone in the suspension time, my lord, is also covered. The double jeopardy argument, first and foremostly, my lord, in my humble submission, what I understand, subject to correction, is only applicable in a criminal case, not applicable in a civil situation. The disciplinary authority can give you punishment, and the criminal law punishment can also come to it. Double jeopardy, it is not the case of double jeopardy. It is a case where the period which you have undergone, that has been taken into consideration. They could have easily given an extended period. They have not done that. Thus, I humbly submit the harshest penalty has not been imposed. And it has been reflected from the second and third point, my lord. Vamsi are allowed to register from subsequent semester 2024. Petitioners will be allowed to participate in the next placement if they are unable to work out suitable arrangement with the organization that they are currently placed in. Let me say this, my lord, that my seniors and petitioner side has pointed out that IIT's rule is you give placement only once. How this is harshest penalty if I am giving you an opportunity again? First and foremostly, someone who is trained in IIT Guwahati like institute, they are not, my lord, their career cannot be finished because of one job. That has been argument been made, very surprising argument. Such a reputed institute of national importance, they are making an argument before this honorable court repeatedly. Look, I will lose the job, my career will be finished. From which institute you have studied? There are people who have not got in a job probably from IIT Guwahati also, whether their career is finished. I humbly submit it is an absolutely inappropriate understanding of the IIT procedure and the brand which IIT has committed, probably has there. It is absolutely fabulous argument, my lord. Let me proceed further. undergo mandatory counseling period. So this counseling support, they have been extended. So they said they have suffered mental trauma and all that. And they have been allowed to undergo some amount of social services. IIT is to be intimated. This punishment was given to them on 22/4/2024. With all seriousness, I submit, my lord, IIT had not used this opportunity which has been canvassed to bypass this honorable court's order somehow or other. This repetition, I had started by saying this, was an unlisted matter. On 26/4/2024, this repetition was filed. And on the same day as an unlisted matter, this order was passed. 26/4, no? Yes. On that day, we did not have proper instruction. It was given let me tell this code, the responsibility of intimating the contents of the order, which is passed on 26/4/2024, was given to my learned colleague by this honorable court. We intimated it probably sometime in the evening by email. That is the process. But the order in this case was passed in 22/4/2024. 24. Not 26, my lord. 26 was an only intimation. Impugn order, which petitioner is impugning, in my humble submission, it is incorrect. That is a communication letter. That communication letter is how? That communication letter, again 4.3 we have to go. It says once the decision has been taken, it has to be approved. Then you can only intimate. After approval, it was intimated. It is only an intimation letter of 26/4. So I humbly submit, my lord, there was not an instance of IIT where the IIT has bypassed it. Now let me just show some law on this point. Let me start by showing Yuvraj Siddharth, please. I will not take too much time. I'll 5 minutes. I'll complete it myself. Not even just paragraphs. I will tell the court. My lord may can take the year. This is a judgment of this honorable court passed in 3618 writ petition 2023. That is, sir, on the issue of PNJ, my lord. That when PNJ can be, the violation of PNJ can be alleged. So in para number 46 of this order, page number WPC 3618 2020.
1 second. WPC
3618 of 2023.
18
of 2023.
opinion.
Yuvraj Siddharth versus IIT.
Reported me.
I do not know that.
Reported me.
Maybe I do not know. So para number 46, my lord. The Honorable Justice Ite was, my lord Justice Ite was writing this. It has been written. A profitable reference may be made to the case of State of UP versus Sudhir Kumar Tupra, wherein Honorable Supreme Court has held that under an analysis, para number 39 of the order has been quoted here, my lord. An analysis of aforesaid judgment thus reveals that natural justice is a flexible tool in the hand of judiciary to reach out to in a fit case to remedy injustice. Breach of audio alteram partem, the rule cannot by itself without more lead to the conclusion of prejudice is thereby caused. Where the procedural or substantive provision of law embodied a principle of natural justice, their infraction part say does not lead to the invalidity of the order passed. Para number 2. Here again, prejudice must be caused to the litigant except in the case of mandatory provision of law, which is conceived not only in individual interest but on the interest of public. Not this. So, my lord, I'm not reading because if my lord wants, I'll read the paragraph, entire paragraph. The law of prejudice this honorable court has laid down. My lord, when at the same breath will see para number 48 also. I'm not reading it again. The observation in the para number 48. Now let me take this honorable court. My lord has seen it? Yeah. So what this honorable court has stated. Yeah, Madras High Court. Then, no, then, yeah, where is this Guwahati High Court judgment? Another judgment was there, no? Guwahati High Court. Yes. My Lord Asim, yeah, let me just take quickly through the. Now, this is a particular case, my lord, of student indiscipline again by Honorable Madras High Court. This is a quorum of Justice M. Satyanarayan. Citation to Sir WBC 9808 of 2015. Citation. B. Baba Ramesh versus Central Board of Secondary Education. 9808 of 2015. 9808 2015. B is Baba Ramesh versus Central Board of Secondary Education and others. Regional. Now let me, sir, my lord. Reported ho pare, my lord. I have taken it from the High Court website. Is reported. This is again a case, Your Honor, my lord. I'm sorry, where this Honorable Madras High Court was looking into the situation of indiscipline, student indiscipline particularly, and how student indiscipline can be handled by the institute. Here, because student indisciplines are generally of two types, my lord. One is academic indiscipline, where you cheat in something, and there are cases where you violate the rules. This is again a case where they have violated the rules and all. Rules of the institute. Para number 17, page 17. The judgment relied upon by the learned counsel. I'm reading para number 17, my lord. Learned 17, it starts. Let me. So the courts, he's referring to the council's argument, and the court submits records the judgment relied upon by the learned counsel. Learned counsel appearing for the third respondent lay down the proposition that it is primary responsibility of head of the institution to see the discipline maintained in the college after placing reliance upon the decision of Umar Raja versus Principal of Medical College, Trivandrum, AIR 1983, KAR 200, sorry, which has held that the essence of the matter is that the head of the institution should in law be presumed to possess an inherent right to do such act as are necessary in his opinion to maintain discipline in the institute, and the right is incapable of an exhaustive identification. To limit it within defined confines would be to erode such authority and fetter his discretion, and to deny right to the head of the institution would be a sound the death knell of the discipline of the institution, which may already be a causality by combination of diverse forces and within and without. Paragraph number 18, my lord. Next paragraph, next page. As per the compliance of principle of natural justice, the reliance would be placed on judgment of Sudhir versus Headmistress H.S. Pannur, 1975 KAR LT 18834, wherein it has been held as follows. A pupil against whom disciplinary action has been taken by the head of the education institution cannot insist that principle of natural justice should be strictly complied with. There is a substantial difference between inquiry in a disciplinary action against a civil servant and that in a disciplinary action against a pupil of an education institute. When a former is a strict compliance of the principle of natural justice is imperative. In the letter, if the pupil has been given a fair chance to answer the charges, that is sufficient. The question is whether there has been fair play. In my humble submission, it is. If the head of the education institution had not in any way acted unfairly, there is no reason why the action taken cannot be sustained. In this case, pupils were informed the charges against them. Then the inquiry was conducted with the staff committee. The pupils participated in the inquiry and gave statement. The decisions was taken with the approval of staff council. People's guardians were informed of the actions proposed to be taken. Only thereafter the pupils were dismissed. This is more than an sufficient compliance with the principle of natural justice in the disciplinary actions against people by the head of the institution. Para 19. In Maharashtra State Board versus of Secondary Education and Higher EA versus KS Gandhi and others, 1991, 2 SCC 716, it has been held that the power of judicial review in case of student discipline is very limited. In such case, the High Court does not sit as an sit in an appeal over the decision of school authorities. Let me very quickly also, I will not now submit, I understand my lord is here. One, our High Court judgment, again, on the issue of disciplinary authority and how the disciplinary authority functions. And how the court sees disciplinary authority. This is a divisional bench judgment. Citation is 2007 2 G, it was Monu citation ase, ye two ase. GLT is citation is 2007 2 GLT 246 and Monu citation is Monu GH 1014 GLT to hoise na. Acha. Party naam is N Mala and others versus Union of India.
M Mala.
And N Mala. So, my lord will state come to page number 3, para number 7. This is a divisional bench judgment, my lord, of this honorable court. Now, what this honorable court is saying in para number 7.
We will continue at 2.
Yeah. This is a divisional bench judgment, my lord, of our honorable High Court, of our High Court. Para number 7, my lord will see. Turn to para number 7, my lord, for a moment. Now, 1, 2, 3, 4, 5, 6, 7, 8th line, my lord. In the last words are starting from the in High Court. My lord has got in the High Court, Judicature of Bombay versus Shashikant S. Party and others reported in 2067 EEC 16. The Honorable Supreme Court, my lord has got that line. My Honorable Supreme Court held that interference with the decision of departmental authorities can be permitted while exercising jurisdiction under Article 226 of the Constitution if such authority had held proceedings in violation of principle of natural justice or in violation of statutory regulations prescribing the mode of such inquiry, or if the decision of the authority is vitiated by considerable externals to the evidence and merits of the case, or if the caprice that no reasonable person would have arrived at such conclusion, not in our case. It is further held that disciplinary committee is the sole judge of the fact. In state of Punjab versus VK Khanna and others reported in 2001 to SCC 330, it has been held that the test therefore is to whether there is a mere apprehension of bias or there is real danger of bias, and it is on this score that the surrounding circumstances must and ought to be collected and necessary conclusion drawn therefrom. It has been further held that general allegations of personal vendetta without any definite evidence cannot be said to be sufficient assertion without acceptance in the court of law. The personal vendetta argument has been also been made advance, my lord. If there was IIT had some vendetta, that is the reason they have been doing in such a manner. Cannot be done, my lord. There must be positive evidence in order to decry an administrative action on the ground of malafide or arbitrariness. None such evidence has been produced before this honorable court. In Bank of India and another versus Degalar Suranaran reported in 1999 1 ILLJ, it has been held that strict rule of evidence are not applicable to the departmental proceedings. Only requirement of law is that the allegation against the delinquent officer must be established by such evidence acting upon which a reasonable person acting reasonably and objectively may arrive at a finding upholding the gravement of the charges. In the same situation in our case also, my lord, the charges are being accepted. Now, let me just quickly take this honorable court through two more arguments and I'll close up. My lord will see this is a recent judgment of Honorable Supreme Court in State Bank of India and others versus. What is your copy? Citation. State Bank of India others versus AGD Reddy. Civil Appeal 1196 of 2011. AGD Reddy. Page number 13. Last page, my lord, can turn. And para number 39. The law has been succinctly put there by Honorable Supreme Court. my lord. The court here was looking. Page number, the last page, my lord, para number 39. Severity of charges, last para. The court here was looking, my lord, when can the, by establishment of how much charges, the penalty can be imposed. The law is well settled that if disciplinary proceeding, the order of penalty can be imposed on charges proved and the punishment imposed is lawfully sustainable on those charges. It is not for the court to consider whether those grounds alone would have weighed with the authority in imposing punishment. So even though one charge has been proved, the punishment can be imposed. It is not court to judge those punishments. No doubt on the facts of the present case, some aspect of charges or the proof may have been found wanting. However, since the law laid down by this honorable court, is that unless punishment imposed is only correlatable to any of those charges found not proved, the penalty cannot be set aside. So, in this case, punishment can be sustained even if charges held not to be proved are severed. So even though those charges which are not proved are severed, still the punishment. So even if the alternative argument, if I presume against myself, my lord, that in an alternative, in a very without prejudice manner, if one of the charges is not been proved and the same is not been severed, still the penalty will sustain and the penalty order will sustain. Now, I complete my without prejudice, my last second phase of my without prejudice argument, my lord. This is a law with regard to non-submission of inquiry report. State of Uttar Pradesh and others versus Prabhat Kumar, Civil Appeal 1567/2019. Our Justice Sudhanshu Dhulia's bench and Hemant Gupta justice was there. Now, para number 6, my lord, can be looked into. Before I make the submission, my lord, let me clarify. This is an absolutely without prejudice argument. That presumably tomorrow this honorable court comes to this finding. Yes, the petitioners were able to show that they have been prejudiced by not giving the inquiry report or the fact-finding report. On such event, what can follow? In such event also, my lord, the power is limited, and that has been captured in para number 6, my lord. That is why what I humbly submit. The allegation against the respondent is an absence of from duty such and such days. It is second line, my lord. Even after the charge sheet was served, the respondent failed to participate in the department proceedings. Such and such is that the court set aside the order of punishment on the ground that the inquiry was not properly conducted. The court should not preclude the employer from holding the inquiry in accordance with law. It must remit the case concerned to the disciplinary authority to conduct the inquiry from the point it stood vitiated to conclude the same in accordance with the law. The court held, I'm not reading the last part again because my lord can see, para number 30. So what I'm submitting, my lord, is that the argument which has been advanced that the fact-finding report was not been given. My lord had asked me, where have you given them the fact-finding report? Now, my lord can take down page number 111 and page number 90 of my, page number 111 of my affidavit, my lord, which I filed in my IA. In the IA, my lord, the affidavit which I filed in my IA.
Yes.
I have narrated page number 111, my lord has got it. Or my lord can take out page number 90 of my writ petition affidavit. Anyone can do.
Yeah, 111.
Yes, my lord. 111. My lord has seen the fact finding committee after interactions with the student has arrived to the following findings. So I have disclosed my lord findings here. The findings were also disclosed during the SDC minute on 22/4/2024 when the SDC minutes were discussed. They have been shared with the findings, observations, and they have been questioned. I have demonstrated that. The court's apprehension which was there, that whether the petitioner has got appropriate opportunity to respond to this, in my humble submission, it has been done at the disciplinary stage itself. Now, let me just point out few paragraphs, and I will not take the court can just take it, probably my lord can take it down. Para number 6, 7, 9, 10, and 18 and 29 of my IA. I'm not trouble this honorable court with this IA. My lord can take down 6, 7, 9, 10, 18, and 29 of my IA reply. My lord can look into the paragraphs. My second last argument is this, my lord. There was an argument made. My lord, shall I repeat?
No,
6,
it's okay.
7, yeah. Second last argument, my lord, is this, that there was an argument being made this honorable court to declare the results. So my lord has seen my preliminary affidavit. I'm not repeating the contents of preliminary affidavit. Preliminary affidavit is there. And para 5, 6, and 7, my lord can take down.
Preliminary affidavit in where?
Preliminary affidavit which I filed in the IA, my lord. We had filed a preliminary affidavit in the IA.
Para.
Para, my lord. Sorry, my lord. Para 4, 5, and 6, 5 will do, my lord. And in the writ petition, affidavit filed in the writ petition, my lord, my para is 5, 6, and 7 at page number writ petition's affidavit, my lord, can take page number 84. In the writ petition's affidavit, para 5, page 84, para 6, page 86, and para 7, page 89. I have dealt in detail what is the IIT's procedure. And my lord can also take down the clauses of the BDS regulation. The clause is 2.5, 9.1, 5.1, 9.1, 9.
Of which regulation?
Of the BDS regulation, my lord, that is been handed over to the honorable court. So you take it out the regulation. So my lord, what happens? While giving a degree, there is an ordinance which this IIT follows. It is called BTEC BDS Ordinance and Regulation. My lord can look into this copy, my lord. I have already handed, but my lord can look into this. I can just keep the regulations. My lord can mark it. It is my copy, so there may be some markings, my lord. 2.5.
1 minute.
My lord.
Yes.
2.5. 5.1. 5.1. 9.2C. 13E.
1 minute.
Sorry, my lord.
9.2 C.
2C.
Then
13E. 15.1. 13E. Clause E 13. Copy আছে একটা হ্যাঁ একটাই কপি আছে one copy only হ্যাঁ করতে দাও
13E or 13C?
My lord, it will be 13C. I'm sorry, probably I've written it wrongly. আমার কোড করা নাই কিন্তু এটা 13 সরি 13 5.1 ইয়াতে নাই What is the law which I'm putting out? I'm law I'm putting.
Yes.
5.15.1 17.1 17.2 19.1 20.1 and 20.2, my lord. If these regulations are looked into, then the argument that this honorable court should give 100% weightage and declare the grades will be, in my humble submission, will be misconceived, my lord. And that will tantamount this honorable court, asking this honorable court to do something which is against the law in this case, my lord. Lastly, my lord, the SCN, my lord, has seen, the charges, my lord, has seen. The charges have been proved, charges have been admitted on the basis of evidences which have been given on that time. I'm not repeating myself because I don't want to take the trouble the court any further. Does that the suspension order which they have ultimately challenged in 26/4/2024? Their argument is they suspend because of the suspension we have suffered such and such, such and such. They have ultimately challenged it in 26/4. If there could have been any attempt by them to approach this honorable court before, the honorable court would have granted them appropriate relief. Thus, this argument that midterm we have suffered and you have not, I've shown no request was made before by them to allow them to write midterm copy. They could have come to this honorable court also. So this is my summary of argument, my lord. I have not touched my IA reply. So if, my lord, I'll submit a short summary of my submissions tomorrow morning, 10:30. And it will be just bulleted points to assist this honorable court, nothing else, my lord. Deeply obliged, my lord.
You want to file your written argument?
My lord, a short summary of my argument, which because other points which I have not touched, that just to page numbers wise, I will give.
That's.
Yes,
Would you also like to file your written argument
yes, I will also file
tomorrow?
tomorrow morning, 10:30.
Can you do it?
Yes, yes, my lord. Yes, my lord.
Okay.
My lord, I'll just, my lord, originals are with the honorable, sorry, sir. My lord, I'll just clarify some
You want to
points.
reply?
Yes, my lord. I'll not take much time, my lord. Just short reply, my lord. The first point I'd like to place before your lordships is with regard to, my friend has said so many things from the records, my lord. Statements are read before your lordships with regard to the quantity of consumption of alcohol, this, that, time of leaving the IIT campus, reaching the hotel, and thereafter, my lord, moving away from the hotel. My lord, I am not on all those facts, my lord. Those facts are before your lordships, my lord. And lordships has to verify those facts vis-a-vis the written statement filed by them before the SDC. Now, my lord, one aspect I would like to clarify, that is with regard to the alternative remedy, my lord. I'll just place one judgment. Regarding alternative remedy, they have said that there is a provision for appeal. Yeah.
Yes.
Para 12, my lord. Second last page. Oh, sorry. 2007, 10 SSC 88. 2007, 10 SSC 88. 10 SSC 88. Para 7. Para 12. Correct. Yes. Take it out.
Yeah.
May I read, my lord?
Before parting with the case, we may also deal with the submission of learned counsel for the appellants that a remedy by way of an appeal being available to the respondent. The High Court ought not to have entertained his petition filed under Article 226, 227 of the Constitution. There is no gainsaying that in a given case, the High Court may not entertain a writ petition under Article 226 of the Constitution on the ground of availability of alternative remedy. But the said rule cannot be said to be of universal application. The rule of exclusion of writ jurisdiction due to availability of an alternative remedy is a rule of discretion, not one of compulsion. In an appropriate case, in spite of the availability of an alternative remedy, a writ court may still exercise its discretionary jurisdiction of judicial review in at least three contingencies, namely where the writ petition seeks enforcement of any fundamental rights, where there is a failure of principles of natural justice, and where the orders or proceedings are wholly without any jurisdiction or virus of an act is challenged. In these circumstances, an alternative remedy does not operate as a bar. There are other judgments which has been quoted by the Honorable Apex Court. So in my humble submission, my lord, there cannot be a bar to the jurisdiction of a writ court, my lord. It's a constitutional court. Yes, there may be cases, but in an appropriate case, whether these are the violations, my lord, the writ court can entertain a writ petition. And lordship will kindly appreciate under what circumstances we approach this court. Our exams were scheduled to be held on 29. We approached on 26. On an emergent situation, we approached this court on 26, my lord. So, this bar of alternative remedy is not there, my lord. This court can exercise, if this court finds a prima facie case, if this court finds that there is violation of principles of natural justice and other violations, my lord, then this court can entertain the writ petition, my lord. Now, my first point on the other day was that the show cause notice, that is 5424, my lord, it contains a proof of the charge that I have stated at para 47 of my writ petition. Now, your lordship will kindly, I'm marking just the paragraph so that, my lord, it will help your lordships, my lord. 47 of the writ petition. My statements, I'm just reading, my lord. Lordship need not to see. The respondents by show cause notice dated so and so for the first time intimated the charges to the petitioner, and by the same show cause notice proved the charges against them. At no point of time petitioners were given any opportunity to place their say against the charges prior to holding the charges to be proved. So this was my contention in para 47, and their reply at para 48 of the affidavit in opposition. Absolutely evasive. I made categorical statement that you hold the charges to be proved in your show cause notice without holding any inquiry. They say, back to state that the show cause notice issued to the student was with the intention of formally informing the students of the charges and violations filed against them. They were given sufficient time of 15 days so that the students could understand and respond the notice accordingly. Also, it may be kindly understood that it is not possible for the committee to file charge against the students unless the entire incident is completely heard and after going through the written statement submitted by the students. Now, they doesn't deny that they did not held the charge to be proved in their show cause notice, which was my categorical statement in para 47. So they have admitted. They have admitted that they have held the charge to be proved by not denying in their affidavit. So this is an admission on their part, because the other side, my lord, since yesterday saying that we have admitted everything. So likewise, my lord, here also they have admitted in their affidavit by not specifically denying that, my lord. So they have admitted, my submission will be, they have admitted that they have held the charge to be proved in the show cause notice. Now, my lord, with regard to the report of the fact-finding committee, my lord, it has become an admitted factual position by now after the deliberation that the fact-finding inquiry report was never given to the petitioners. And that fact-finding inquiry was relied on, if your lordships goes to the affidavit file, in my lord, while coming to the conclusion by the SDC. Now, to that extent, my lord, the other day I have referred, I have given only the relevant paragraphs, my lord, because the judgment was a bulky. So that's why I have, it is ECIL versus B. Karunakar. 1993 4 SCC 727. It is a constitutional bench judgment, my lord.
Yes.
Look, I'll just read two paragraphs. While the right to represent against the finding of the para 25, 26, 29. While the right to represent against the findings in the report is a part of the reasonable opportunity available during the first stage of the inquiry, viz. Before the disciplinary authority takes into consideration the findings in the report, the right to show cause against the penalty proposed belong to a second stage when disciplinary authority has considered the findings in the report and has come to a conclusion with regard to the guilt of the employee and proposes to award penalty on the basis of its conclusions. The first right is the right to prove innocence. The second right is to plead for either no penalty or lesser penalty, although the conclusion regarding the guilt is accepted. It is the second right exercisable at the second stage, which was taken away by the 42nd Amendment. Now, para 26. The reason why the right to receive the report of the inquiry officer is considered an essential part of the reasonable opportunity at the first stage, and also the principles of natural justice, is that the findings recorded by the inquiry officer from an important material before the disciplinary authority, which along with the evidence is taken into consideration by it to come to its conclusion. It is difficult to say in advance to what extent the said findings, including the punishment, if any, recommended in the report would influence the disciplinary authority while drawing its conclusions. The findings further might have been recorded without considering the relevant evidence on record or by misconstruing it or unsupported by it. If such a finding is to be one of the documents to be considered by the disciplinary authority, the principles of natural justice requires that the employee should have a fair opportunity to meet, explain, and controvert it before he is condemned. It is negation of the tenets of justice and denial of fair opportunity to the employee to consider the findings recorded by a third party like an inquiry officer without giving the employee an opportunity to reply to it. Although it is true that the disciplinary authority is supposed to arrive at its own finding on the basis of evidence recorded in the inquiry, it is also equally true that the disciplinary authority takes into consideration the findings recorded by the inquiry officer along with the evidence on record. In the circumstances, the findings of the inquiry officer do constitute an important material before the disciplinary authority, which is likely to influence the conclusions. If the inquiry officer were only to record evidence and forwarded the same to the disciplinary authority, that would not constitute an additional material before the disciplinary authority of which the delinquent employee has no knowledge. However, when the inquiry officer goes further and records his finding as stated above, which may or may not be based on the evidence on record.
Thus,
I'm sorry.
I'll read it later.
Sorry, Mr. Yes, fine, Mr. So these three paragraphs I am relying on. And Lord, I'll just reiterate. There is two punishments, suspension and this one. and yes, my lord. And one more submission that has been made, that relying on a Supreme Court judgment, that even if the inquiry report is not furnished, the only conclusion or only remedy left before this honorable court is to remand back. My lord, in my humble submission, this is not a case wherein only inquiry report has not been furnished. There are multiple violations along with hostel level violations and institution level violations. So under that circumstances, It is not a case wherein, my lord, for that purpose only it has to go back. So there are multiple violations in the present case. So this impugn order, this is required to be interfered. Look, to small judgment, I am just placing just two lines I'll read, my lord, nothing more. One second, DS. With regard to admission, my lord, my friend is making a submission that all the allegations admitted, my lord. In my humble submission, if your lordships, consider the written statement submitted by the petitioners at page, lordship will kindly note it down, the page number of the written statement that was submitted by the petitioners to deny the charges, page 61. So if this page 61 is considered, my lord, no reasonable person properly instructed in law will come to a conclusion that they have admitted. Now, para 11, I am relying on. Roundabout, the line starts, but apart from this consideration, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Above 18 lines, Article 311(2), lordship is final. Just above that, my lord. But apart from this consideration, if the statements made by the appellant do not amount to a clear and unambiguous admission of his guilt, failure to hold formal inquiry would constitute a serious infirmity in order dismissed against him. So if you want to act upon our admission, that admission has to be, my lord, clear and unambiguous. It should not be qualified by any reason given, that for this reason, that reason. It has to be clear and unambiguous, which is not the case here, my lord. Citation is 1960 SCC online SC 68. Online SC 68. So there is no clear and unambiguous admission. And if it was an admission, why you have conducted an inquiry? You are not required to conduct an inquiry. You could have imposed punishment there and then. So this is my submission. It was paragraph. Look, this is 1984 SCC 379. 4 SCC 379. Paragraph 24. Lord, only 3 lines, just I'll read, my lord. 3 lines, para 24. In para 24, my lord, the Honorable Apex Court has dealt with the natural justice. What is natural justice? Then the conclusion, para 24 down below, my lord. In our view, lordship has got down below. Yes. Yes. In our view, the principles of natural justice know of no exclusionary rule dependent on whether it would have made any difference if natural justice had been observed. The non-observance of natural justice is itself prejudice to any man, and proof of prejudice independently of proof of denial of natural justice is unnecessary. If it ill comes from a person who has denied justice, that the person who has been denied justice is not prejudiced. As we said earlier, when an admitted or indisputable facts, only one conclusion is possible, and under the law, one penalty is permissible, the court may not issue its writ to compel the observance of natural justice, not because it is not necessary to observe natural justice, but because the court do not use futile writs. We do not agree with the contrary view taken by the High Court in the judgment. So it says, the Honorable Apex Court has held that we need not go search what prejudice has caused. The factum that natural justice is violated in itself is a, my lord, instance of causing prejudice, my lord. So that is my basic submission, my lord. And so far as my phrase contention, that my friend has referred some, my lord, ordinance with regard to declaration of result. My lord, we are at all not concerned with what are those ordinances are, because those ordinances provide withholding of result only during the pendency of disciplinary proceeding. Lordship has seen, if there is a disciplinary proceeding pending, that they can withhold result. They have already withheld the result. So that is not, once the fate of the impugn orders are decided, my lord, there has to be a consequential direction to declare the petitioners to be passed by giving 100% weightage. Because I should not fail or I should not suffer for your lapses. You impose a suspension from January to April, and thereafter, my lord, penalty order giving retrospective effect. How can you have the cake and eat it too, my lord? So that is precisely my humble submission. My lord, one small prayer, my lord, lordship will pardon me for making this prayer. Their regarding their offer of appointment, my lord, I have already expressed. So perhaps by the next week they'll have to join. I don't know whether early part of the next week or later part of the next week. Lord, lordship will kindly pardon me for making this prayer, my lord. There is some urgency in the matter, my lord. I beg apology. I know the workload, my lord. Even then, my lord, I'm making a prayer. It's my duty before your lordship, my lord. Lordship will kindly consider that, my lord.
Well, the original record, my lord, may be kept with the honor. Does that, my lord, this
Also heard MS, Mr. ABD. The council. Appealing for the respondents. 3-2.
3-7, my lord.
You want it tomorrow?
Which one, my lord?
You want it to be listed tomorrow?
My lord can keep it.
No, lordship can.
No, we'll list it tomorrow, then you give it, we'll conclude it tomorrow.
Fine, my lord. We'll just place a
No, it will not be listed. We can just place it.
No,
Sometimes the records will go here in the.
Fine, my lord. Absolutely fine.
This for Friday, again, or tomorrow's 19th. Also heard MS and then Shama. We're not CGC. For the respondent, one is.
Deeply obliged. Like that document matter is which one?
Records and keep.
Yes, my lord. My lord can also keep the books. It will. Nice.
Records and keep it in the tomorrow. Huh? Present. Okay, then I'll have.
Highly obliged, my lord, for the patient hearing.
Deeply obliged.
Thank you so much. No. It's absolutely fine.
It is so bad, you will not believe.
No.
And how much I have got,
No,
you will not believe.
no.
Yeah.
Item 1 of daily list, hearing.
Lordship, the assisting counsel for this case on behalf of NIA, he is engaged in some other urgent matters. So I beg your lordship to adjourn the matter for today.
Who's the counsel?
The assisting counsel, he is the senior public prosecutor for NIA.
Who's the senior public prosecutor?
Satyanarayanan.
Huh?
Satyanarayanan.
So you want some accommodation today?
Lordship?
You want an adjournment?
Yes, lordship.
You are appearing for the?
What are all the respondents for as Botagod, representing as Botagod for all the respondents.
Okay, on request made on behalf of the learned senior,
A senior PP and senior PP and I, Satyanarayana.
senior PP for the appellants. List the matter after.
Next one on Lordship may fix on
Fixing the date, it's not be possible. We don't know whether will be one of us.
okay,
will
Lordship,
be-
any day,
After how many weeks?
next month, any day, your Lordship.
After 3 weeks.
Hello.
Okay.
Obliged. Obliged, Lordship.
Turn mention of item number 19. I could not actually mention in the morning due to some personal difficulty. The Lordship, item number 19, as per my learned friend was supposed to provide me the details of the selected candidates. He just provided me in the morning and I have to implead those selected candidates in the prediction. So I need to
Okay.
file an IA for impleading them. So I take 2 weeks time to file the IA.
Mr.
D. Bora.
Learned counsel for the petition. Praise for 2 weeks. time to enable him to file an appropriate application for implement of necessary part. Praise the Lord. List of the 2 weeks.
I'm for the Assam University.
CACKL, Learned Standing Council appears for the Assam.
Much of.
Obliged, Lordship.
Admission.
I can't proceed. We'll fix a date, Kadir. I can't proceed later. I'm having a big problem.
My lord, otherwise it will be, my lord, fixed on a date. But my lord, one thing is that it is a very urgent matter, my lord.
I know, but
Okay.
today I can't
Yes,
proceed.
yes.
I have some serious problem.
Yes, my lord.
So-
Can it be on Tuesday, my lord?
This matter on 23rd July.
My lord, there may be,
My lord.
at two may be taken up, my lord, because
That
other-
day you mentioned.
on that day, probably.
My lord, can it be on 25th? On 23rd, I have another fixed matter before the cat matter.
My lord, then on Monday, my lord, because my
Monday,
lord,
Monday it can
Ma-
be listed.
my lord, the already admission process started,
Yes,
my
my
lord.
lord, Monday,
We will
22nd, my lord.
oblige, my
22nd.
on Monday.
Obliged.
Any urgent matters? No. Any urgent matters?